The case of Association of International Shipping Lines Incorporated, APL Company, PT Ltd., and Maersk Philippines, Inc. v. Secretary of Finance and Commissioner of Internal Revenue examines whether demurrage and detention fees collected by international shipping carriers should be taxed under the regular income tax and VAT or as part of the 2.5% Gross Philippine Billings (GPB) tax. Let's break down the facts, the issue, and the Supreme Court's ruling. In 2008, the Commissioner of Internal Revenue, CIR, issued Revenue Memorandum Circular No. 31 to 2008, RMC 31 to 2008, which subjected demurrage and detention fees to regular corporate income tax and VAT. Demurrage fees are charged for the delay in unloading inbound cargo. Detention fees are charged when consignees fail to return shipping containers on time. The international shipping carriers argued that these fees are incidental to their primary business and should be taxed only under the 2.5% GPB tax as provided in Section 28A.3.b of the National Internal Revenue Code (NTRC). In 2010, APL Company, PT Limited, Maersk Philippines, Inc., and the Association of International Shipping Lines filed a petition for declaratory relief before the Regional Trial Court (RDC) of Quezon City, challenging the validity of RMC 31 to 2008. The RDC ruled in favor of the petitioners, declaring the circular invalid, and held that demurrage and detention fees are incidental to international shipping and should be taxed under the 2.5% GPB tax. The law does not explicitly impose VAT on these fees. However, in 2013, despite this ruling, the Secretary of Finance issued Revenue Regulation No. 15 to 2013, reiterating the position that demurrage and detention fees should be subject to regular income tax and VAT. The petitioners filed another petition challenging the new regulation, but the RDC dismissed it, prompting them to bring the case to the Supreme Court. The issue is whether demurrage and detention fees collected by international shipping carriers should be subject to regular corporate income tax and VAT, or should they be taxed as part of the 2.5% GPB tax regime. The Supreme Court ruled against the petitioners, holding that demurrage and detention fees are not part of the GPB and are subject to regular income tax and VAT. The court reasoned that these fees are not directly related to the international transportation of goods, which is the core activity taxed under GPB. Demurrage and detention fees are income derived from the use of shipping carriers' property, containers, in the Philippines. Therefore, they should be taxed under regular corporate income tax and VAT as income from sources within the Philippines. The principle of residential judicata does not apply, as the previous RDC ruling only covered RMC 31 to 2008, while RR 15 to 2013 was issued by a different authority, the Secretary of Finance. This case clarifies that demurrage and detention fees are not part of international transport earnings, but are instead local income subject to Philippine taxation. The ruling highlights the importance of proper tax classification in global shipping and reinforces the government's authority to regulate taxation on revenue generated within its jurisdiction.